1 year ago, the Supreme Court handed down a 5-4 ruling that most Americans never fully understood, and it still controls exactly how the federal government can remove people from this country under a wartime law that hadn't been meaningfully used in generations. If you've heard the phrase Alien Enemies Act thrown around in the news without ever getting a clear explanation of what the court actually decided, or why 4 justices, including one appointed by the very president whose policy was at stake, dissented so sharply, this breakdown is for you. On April 7, 2025, the Supreme Court ruled 5-4 in a case called Trump versus J.G.G., and that ruling didn't just resolve one emergency application about a handful of deportation flights. It set a template for how courts handle nationwide injunctions, class action lawsuits, and emergency judicial intervention that has been cited and relitigated ever since, right up through this year. I'm going to walk you through exactly what happened, what the majority actually held, what the dissent warned about, and why this case, over a year later, is still shaping how federal courts respond when a president moves fast and the judiciary tries to catch up. Before we get into it, if you want the actual legal reasoning behind stories like this instead of the flattened partisan version that dominates social media, subscribe and turn on notifications right now. I track these rulings and their aftermath for as long as the story stays live, not just for the first news cycle. Let's get into exactly what happened. Here's the background you need before the ruling makes sense. On March 15, 2025, the Trump administration invoked the Alien Enemies Act, a law passed in 1798 that allows the president, during a declared war or an invasion by a foreign nation, to detain and remove citizens of that hostile nation without the individualized removal proceedings normally required under immigration law. The administration argued that the Venezuelan gang Tren de Aragua's activity inside the United States amounted to an invasion for purposes of the statute and used that authority to begin deporting men the government identified as gang members directly to a maximum security prison in El Salvador known as CECOT. A group of Venezuelan men in U.S. custody who were about to be removed under this proclamation filed an emergency lawsuit, arguing their removal without any hearing or opportunity to contest the government's identification of them as gang members violated due process. The case landed in front of U.S. District Judge James Boasberg in Washington, D.C., who issued a temporary restraining order that same day, ordering the administration not to proceed with the removals and, according to later court filings, specifically ordering that any planes already in the air carrying deportees be turned around. The administration did not turn the planes around. Those flights landed in El Salvador, and the men aboard were transferred into CECOT custody. That single fact, planes in the air when the order was issued and not turned around, became the spark for a much longer legal fight that has continued for more than a year. The Alien Enemies Act itself is worth pausing on before we go further, because its history is part of why this case generated so much attention. Passed in 1798 as part of a broader package of laws responding to fears of war with France, the statute has been invoked only a small handful of times in American history, always during a formally declared war. It was used during the War of 1812, during World War I, and most notoriously during World War II, when it provided part of the legal basis for detaining tens of thousands of Japanese, German, and Italian nationals living in the United States, a chapter of American history now widely regarded, including by later courts and the government itself, as a serious civil liberties failure. The 2025 invocation was unusual, specifically because Congress had not declared war on Venezuela, and the administration's legal theory rested on treating the activity of a criminal gang, rather than the formal armed forces of a foreign nation, as the kind of invasion the 1798 statute was written to address. That novel legal theory, applying a wartime statute to gang activity rather than a declared war, was itself hotly disputed among legal scholars before the case ever reached the Supreme Court, and it remains disputed today, because the Supreme Court's April 2025 ruling never actually resolved whether that application of the statute was lawful. It resolved only where and how that question had to be litigated. The first segment of this story is the procedural path the case took before it ever reached the Supreme Court, because understanding that path explains exactly what question the justices ended up deciding. After Boasberg's initial order, the plaintiffs expanded their case into a class action, seeking to represent all non-citizens in U.S. custody who were subject to the same Alien Enemies Act proclamation, not just the individual men who had originally sued. Boasberg extended his order to cover that broader class, effectively blocking removals nationwide while the case proceeded. The Federal Appeals Court in Washington, in a divided ruling, declined to lift Boasberg's order, allowing it to stay in place. At that point, the Trump administration went directly to the Supreme Court on an emergency basis, asking the justices to vacate Boasberg's order entirely, arguing the case never should have been filed as a class action seeking nationwide relief through a temporary restraining order in the first place, and that the proper legal vehicle for challenging removal under a law like this was an individual habeas corpus petition filed in the specific location where each detainee was being held, not a broad class action in Washington, D.C. The second segment is what the Supreme Court actually decided, and it's worth being precise here because the ruling is narrower on paper than it felt in practice. In an unsigned per curiam opinion, meaning the court did not identify a single author and instead issued the ruling as a decision of the institution itself, the 5-justice majority vacated Boasberg's temporary restraining orders. The core legal holding was jurisdictional and procedural, not a ruling on whether the Alien Enemies Act itself was being applied lawfully to these men. The majority held that individuals challenging their detention and removal under the Act must do so through habeas corpus petitions, and that those petitions have to be filed in the judicial district where the person is actually being confined, which in this case meant Texas, not Washington, D.C., where the class action had been filed. This distinction between a habeas petition and a class action seeking broader injunctive relief is not just a technicality, even though it can feel like one. Habeas corpus, one of the oldest legal protections in Anglo-American law, allows a person in custody to challenge the legality of that custody directly, but it has traditionally been understood as an individual remedy, filed by or on behalf of one specific detainee in the specific court, with jurisdiction over wherever that person is being held. A class action, by contrast, allows one lawsuit to represent the interests of a much larger group all at once, and a court hearing a class action can issue relief covering everyone in that class regardless of where each individual member happens to be located. The majority's position was that Congress, when it wrote the habeas statute governing challenges to this kind of detention, specifically intended the individualized, location-specific version of review, not the broader class-wide version, and that using a class action to secure nationwide relief through an emergency temporary restraining order stretched the available legal tools beyond what the underlying statute actually authorized. Importantly, and this detail gets lost constantly in how this case gets summarized online, the majority opinion explicitly stated that individuals subject to removal under the Alien Enemies Act are entitled to adequate notice and an opportunity for judicial review before they can be removed. The court did not rule that the administration could deport people under this law with zero due process. It ruled that the specific due process owed had to be litigated through individual habeas petitions in the right jurisdiction, not through a class-wide temporary restraining order issued by a single district judge in Washington covering everyone potentially affected nationwide. The third segment is the dissent, and it deserves to be presented in full because the reasoning matters just as much as the outcome. Justice Sonia Sotomayor, joined by Justices Kagan and Jackson, and notably joined in significant part by Justice Amy Coney Barrett, a justice appointed by President Trump himself during his first term, dissented sharply from the majority's decision to intervene on an emergency basis before the lower courts had even finished their ordinary process. Sotomayor's dissent argued that the case involved potential life or death consequences for the men who had already been removed to a foreign prison, and that forcing individuals to file separate habeas petitions in Texas, often without meaningful access to counsel and on an extremely compressed timeline, functionally denied them the very judicial review the majority claimed to be preserving. The dissent pointed out that the government itself had, by that point, already flown roughly 137 men out of the country under the proclamation before any court had definitively ruled on whether the underlying use of the Alien Enemies Act was even lawful, and argued that vacating Boasberg's order at this stage rewarded the administration's decision not to comply with a standing court order by removing the very forum, a class action with nationwide reach, that could have provided a remedy. What made this dissent unusual and worth understanding on its own terms was Justice Barrett's partial break from the other 5 Republican-appointed justices. Barrett is one of the most reliably conservative members of the court on many issues, and her willingness to side with the 3 liberal justices here signaled that at least some of the disagreement in this case was not a simple ideological split, but a genuine disagreement about the proper role of emergency judicial intervention itself. The 4th segment is the argument the administration made, and it deserves to be presented on its own terms too, separate from how it's often characterized. The government's core position was about institutional roles, not about the merits of the underlying immigration policy. Their argument was that national security determinations, including who counts as an alien enemy under a statute Congress passed specifically to give the president wartime authority, belong constitutionally to the executive branch, and that a single district court judge issuing a nationwide temporary restraining order effectively allowed one judge to override the president's judgment on a sensitive national security matter before the ordinary appellate process had even run its course. In their filings, government lawyers framed the dispute as a fundamental separation of powers question, arguing the case presented the basic issue of who decides how to conduct sensitive national security operations in this country, the president acting under Article 2 of the Constitution, or individual federal judges acting through emergency temporary restraining orders. The administration argued that this pattern, lower courts issuing sweeping nationwide relief through emergency temporary orders rather than through the normal, more deliberate process of full litigation, was itself a problem worth the Supreme Court correcting, regardless of how any individual case eventually resolved on the merits, and pointed to a broader trend of federal district judges issuing nationwide injunctions against various executive branch policies in the preceding years as evidence that the judiciary had drifted into a pattern of overriding presidential authority through emergency procedural mechanisms never designed for that purpose. Whether or not you find that argument persuasive as applied to this specific case, it reflects a broader, genuinely held position about the separation of powers that predates this particular immigration dispute and has been argued by administrations of both parties at different points when facing nationwide injunctions they viewed as judicial overreach, including arguments made by the Obama and Biden administrations when their own policies were blocked nationwide by individual district judges in years past. The 5th segment is what makes this case matter beyond the immediate dispute over these specific deportation flights. The Trump versus J.G.G. ruling became an early and influential example of the Supreme Court using its emergency docket, sometimes called the shadow docket, to resolve procedural questions about how and where major challenges to executive action have to be litigated, often without full briefing, oral argument, or a signed opinion explaining the court's full reasoning. In the year following this decision, legal scholars tracking the Supreme Court's emergency docket have noted that the volume of emergency applications reaching the court and the frequency with which the court has granted relief to the executive branch on procedural grounds similar to the reasoning in J.G.G. increased substantially compared to previous years, sparking a genuine and ongoing debate among judges, legal scholars, and even the justices themselves about whether major questions of executive power should be getting resolved through unsigned expedited emergency orders rather than through the court's normal fully briefed process. This is not a purely academic concern. When a case reaches the court through the emergency docket, the public typically gets a short, unsigned order with limited or no explanation of the majority's full reasoning, sometimes just a paragraph or two, compared to the dozens of pages of analysis that accompany a fully briefed merits decision. Justice Elena Kagan, among others, has written and spoken publicly in the years since about her concern that deciding consequential legal questions this way, quickly and with minimal public explanation, makes it harder for lower courts, for Congress, and for the public itself to understand exactly what the law actually requires going forward, since a short, unsigned order provides far less guidance for future cases than a fully reasoned opinion would. The sixth segment is what happened on the ground to the specific men involved in this case, because the procedural ruling had real, immediate human consequences that continued playing out long after the Supreme Court's order. The roughly 137 men who had already been transferred to CECOT in El Salvador before the Supreme Court's ruling remained in that facility for months, while the underlying legal fight over their status continued in the lower courts, now proceeding through the habeas framework the Supreme Court had specified rather than through Judge Boasberg's original class action. Separately, Judge Boasberg found probable cause to hold administration officials in criminal contempt for what he characterized as willful disregard of his original order not to complete the deportation flights, a finding that triggered its own extended legal battle over the following year, working its way through the D.C. Circuit Court of Appeals on a completely separate track from the underlying merits of the Alien Enemies Act dispute itself. The seventh segment is what this actually means for you, practically, if you want to follow how cases like this develop going forward. Understand that a Supreme Court emergency ruling like this one resolves the immediate question in front of the justices. Here, which court and what kind of lawsuit? But it does not necessarily resolve the underlying legal question everyone actually cares about here, whether the administration's use of the Alien Enemies Act against this specific group was lawful in the first place. If you want to track a case like this accurately going forward, the concrete step is to distinguish between rulings on the emergency or shadow docket, which tend to be about jurisdiction, procedure, and where a case belongs, and rulings on the merits docket, where the court fully briefs and argues the actual underlying legal question and issues a signed opinion explaining its reasoning. Confusing the two, treating a procedural emergency ruling as if it definitively resolved the underlying policy dispute, is exactly how so much of the public conversation about this case got confused within days of the ruling coming down, and it remains one of the most common ways major Supreme Court news gets misreported or oversimplified more broadly. Let's step back and name the single thread running through this entire case. This was never really a ruling about whether Tren de Aragua's activity in the United States legally qualifies as an invasion under an 18th century statute, even though that's the question most people assumed was being decided. It was a ruling about who gets to decide where and how that question gets litigated. A district judge in Washington issuing sweeping nationwide relief through an emergency temporary order, or individual courts handling individual habeas petitions in the specific places where each affected person is actually held. The 5-justice majority sided with the narrower, more individualized process. The 4-justice dissent, including a justice appointed by the very administration whose policy was being challenged, argued that narrower process functionally denied meaningful judicial review to people facing what the dissent characterized as genuinely life or death consequences. Both sides were arguing about deeply held, legitimate principles, the proper limits of a single district court's power to bind the entire country through emergency relief on one side, and the practical reality that forcing detained, often non-English speaking individuals to separately litigate habeas petitions on a compressed timeline can amount to no meaningful review at all on the other. It's worth sitting honestly with why this particular case produced such an unusual coalition, because it tells you something real about how these questions cut across the ordinary ideological lines people expect from the court. Justice Barrett's partial break from the other 5 Republican-appointed justices was not really about immigration policy itself, and nothing in her writing suggested sympathy for the underlying claim that Tren de Aragua's activity did or did not amount to an invasion. It reflected a narrower but genuinely significant concern about the pace and posture of the emergency docket itself, whether the court should be intervening this quickly, on this thin a record, to override a district court that was still actively working through the case on an expedited schedule of its own. That kind of disagreement, about process and institutional restraint rather than about the underlying policy, shows up more often on this court than the simple partisan scorekeeping in most headlines ever captures, and this case is one of the clearest examples of it from the past 2 years. If there's one thing worth taking from this breakdown, it's that a 5-4 Supreme Court ruling is rarely as simple as winners and losers on a single policy question. This case shaped how nationwide injunctions and class action challenges to executive power get handled for years afterward, influenced how lower courts and the Supreme Court itself have approached a wave of subsequent emergency applications, and left a group of real people sitting in a foreign prison while the procedural question of which courtroom their case belonged in got sorted out above their heads. Understanding both the narrow legal holding and the much larger stakes riding on it is the difference between actually knowing what happened on April 7th, 2025, and just repeating whichever side's talking point reached your feed first. If this helped you understand a case that's still shaping the news a year later, share it with someone who's heard the name Alien Enemies Act without ever getting the full picture. Subscribe so you catch the next major ruling the moment it drops, and I will see you in the next one.